They may not know what arguments to make, based on the claim. And they can go and get more evidence, and they can go and request more evidence and documents, but it's with the claimant. And really, the thing is that I don't even know if an MP in a committee is the equivalent of a duty solicitor or not. Because the MPs are all meant to kind of be equal, and the thing is that the chair of the committee, and when you have like a chair, in these committee sessions, you have like three ministers who are like the chair, like three magistrates, right? They're appointed to basically they make sure that everyone speaks and organise it all like a court, right? But they make the order, and after they've made the order, they're meant to go tell the speaker that they had a hearing and they made the order. Like it's like a mini. It's like the sessions in. The thing is, in open parliament, right? You have sessions, but sometimes it's empty and hardly any MPs turn up, but they're still doing stuff, right? The committee meeting is almost like that, but in a small room, so it looks fuller, right? And they make a decision, and when they've made a decision, they go tell the speaker, and then the speaker's meant to go put it through officially, you know? Really, that's going to be what it's like, as far as I can gather. And the problem is that, this is the thing, right? The MPs in the committee, or at least in the type of committee when they're voting and an order's made, right, all the ayes and all the nays, all the votes, right, they're voting, right, they are making a decision in favour or against. That is the juror's job. In a court, the jury vote. If you don't have a jury, then the magistrate decides, right? Now, in the committee, they appoint some of the MPs as the equivalent of the magistrates, and the rest of the MPs, the ones who vote on it, yea or nay, like a jury, and then the three on the panel then hit the hammer down and make the order, right? Now, this is the thing. In a courtroom, the duty solicitor isn't the jury. He doesn't get to vote guilty or not guilty. He presents evidence. And the Crown Prosecutor cannot decide who is guilty or not guilty, right? They can both present evidence and make a case for or against. Now, this is the thing. In the committee meeting, you've got someone has to present the evidence and make the case, and they debate it, right? They can give evidence, but the evidence comes from the claimant, right, which they've submitted, but they can also get more evidence. But the thing is that the whole thing is kind of being orchestrated. You've got a claimant and you've got a public gallery, because the public can, like Tess Lowry sat there because it's her petition, and she collected the evidence and submitted the evidence and facts of the claim. And that evidence also is 116,000 people's evidence of public concern. Could have been more, could have been 3 million. But also, she submits documents and evidence and so forth. But in court, if Tess Lowry went to a civil court to prove X, Y, or Z, or that, the World Health Organization shouldn't, dabble with our rights or whatever, right? Then if she could get a lawyer, but she and her lawyer are working together as one unit to bring evidence, to get evidence, and then to make the case to the court, right? Your lawyer works with you as one body, really. They're just learned and experienced in the proceedings of the court, right? I mean, you can go to a lawyer and know nothing and say, can you help me? I've committed a crime. Can you prove that I'm innocent? But they question you. They ask you for evidence. If you've committed a crime, right, your solicitor doesn't, you don't sit there in a chair like a dummy and do nothing. Your solicitor just doesn't go off and research. He is already meant to know all of the law around all of the things. But he needs material. Law's no good purely on law unless you're just arguing the law itself, right? Which you can do that. You can just argue legislation over legislation, purely only having acts of law in front of you using logic, right? You can do that. But usually if you've got a case to bring, it's usually about something that's happened somewhere around, right? Now, if you've been accused of a crime, right, the solicitor just doesn't go off and grab things like, I don't know, evidence, jackets, statements, things of his own accord. He asks you, what did you do? You give me a statement. I'm asking you. The evidence is coming out of your mouth, right? Where were you on Tuesday? Can you prove that you were at the seaside? Tell me this, tell me that. Explain what you meant about this. Explain what you're feeling about that. It's you. Did anyone else see you? What are their phone numbers? Let's go see them. Let's get a statement, right? It's all evidence coming from you. You're the client. You're the person with the problem. You're the person with all the information, right? You go to him because he's an expert in that law and he already knows all that law, right? There's nothing more for him to learn. Every bit of information about the case is from you. You are the information, right? Now, when you're wanting to get a law made or changed, everyone's meant, in Parliament, they're meant to already know all of the legislation, at least to the proficiency of a lawyer already knowing all the law. But why you should get the law changed or why you want the law changed, anyone can have the law changed in any way they want. But you are coming saying that we, right, me and these people who have signed it, want the law changed to this or that. But why? Why should we do that? Well, the political parties have already got their own agendas and manifestos, whether they support it or oppose it, right? But the more evidence that you bring and lay proves to those MPs why they should vote in favour of your request. Now, if the MPs' parties already have a position on it, they're unlikely to go out of their way to get more evidence to prove their own party or themselves wrong. It's you, the independent person, who is laying the evidence to compel them to vote in your favour. Now, that's like going into a court on a table and getting the jurors to vote in your favour, right? But if you are restricted on what evidence you can give other than a massive amount of people supporting it, you can have all the people on the planet supporting it, but it might not prove them to vote in your favour or not, you know? And there's something very troubling now in my mind that I've got about this difference between the MPs voting yay or nay in favour or against it when they're the ones who are each of them giving some evidence. Because that's like the juries themselves giving evidence, but then the juries themselves voting, which is when particularly half of them already are in a particular party that opposes it, or half of a party that particularly supports it. It's odd. And surely what they debate, therefore, cannot be purely... You can't have the jury you can't come into court and say, excuse me, I'd like to file a case. I'd like to prove, that I'm guilty or not guilty, or this or that. And then the jurors go off, and the jurors are the ones who get the evidence, and then they come back, and then depending on what evidence they've got, then they're the ones who decide whether you're guilty or not, because they might just can't be asked to get decent evidence, or some of them might get evidence strongly against or for, which you're the person who submits the case, and you're the person who brings the evidence. And the MPs are kind of, they've got a hybrid position, which is somewhere between a duty solicitor and a jury. But the thing is that they're mainly debating in the chamber, and they can compel witnesses to come, and they can compel evidence. But this is the thing, who's directing them? Because in a court, the person who brings the case, both the defendant and the respondent can give directions. And it's this is what we're arguing with the committee. Is this giving directions part? When you give directions, you can say, well, I've got this evidence, but I, the claimant, the plaintiff, the petitioner, I know that there's some very strong evidence here or there also, but I don't have access to it, or I'd like to get it. Can we have a warrant for it, or can we have a subpoena? This is the thing. And this is, also, how do you get the public to support it? Well, when they read the petition and read the complaint, they got to look at it, and they got to say, this is very compelling, I'm going to sign this. You wouldn't sign anything until you read the complaint. This is the thing. You won't put your name to anything and sign it unless you've seen the grievance, the complaint, the writ. And they're not letting you publish it on there if Parliament don't like it. We'll say, no, the case is too strong, or the case doesn't make Parliament look good, or this or that. We don't want people to sign that. Well, it's almost kind of like saying, don't vote for Labour. Oh, we don't want everyone to see this sign saying, don't vote for Labour or whatever. They're letting party politics get in the way of, and their party policies, manifestos get in the way of our individual cases. It's almost kind of like saying, it's almost kind of like saying, well, it is. It's like saying if you went into Congress, right, and you had a case to Congress that you wanted to make chocolate bars illegal, right, and Nancy Pelosi, the Speaker of Congress, said, I rejected this petition because I've got shares in Cadbury's, right? She's rejecting the petition because she doesn't want you to make chocolate bars illegal because she's got shares in Cadbury's. Or the Democrats like chocolate bars because it makes them a lot of money on the stock exchange. It's like that. That's how corrupt it is. That is the corruption of it. They're getting their own party's politics involved because they've got ulterior motives. And this is like in court if you had a Labour jury. If you had a Labour Party jury, it would be no good for a Tory. They'd be screwed. And this is the thing. This is why they remove the juries from magistrates' courts, and why they remove the juries from civil courts and from the council as well, from council matters, because they didn't want working class Labour juries to say, no, you're not building a biscuit factory, or no, Johnson's investment company limited, who are assets of £20 billion, aren't building a new housing estate next to my house because I don't want it there, right? And why they started saying, Baron, Countess, Dame Theresa and Baron Munchausen have divorced, and they didn't want a Labour jury to say, fucking hell, that's all the money that we worked for in factories that the fleece from us, and now just because Dame Cricket's gone and shagged some Biggles pilot from fucking Kent, now they're splitting up and she's running off with £20 billion, which, just for having a shag, which is why all the factory workers have been working there fucking 8 days a week at slave labour, and they've got peanuts. And effectively, what they did is they made factory workers, they made factory owners, business owners, big corporate persons, they made them into peers, privileged peers, by removing the juries, because then privileged persons, big business people, didn't have to have poor people, right, judging them in court and what they can and can't do. But the real life peers, the privileged life peers, right, what the royals did is they said, they pretended that we're removing the privileges. They're removing the Magna Carta privileges, so then they can be tried by courts. But they're not being tried by courts because they removed all the juries from the lower courts. So they actually ended up they hadn't really. It's a bit of a con, a fleece, a trick. It's like a cup under the ball trick, because they said, oh no, they pretended that the peers don't have privileges anymore, right? When they can't be removed because of Magna Carta, but they pretended that we removed them, but really they hadn't, because what they'd done is they're never going to be judged by poor people, because poor people were removed from the juries. So even if Lord Hanningfield gets a speeding ticket, right, he's not going to be judged by a jury of working class people in a court. He's going to be judged by the magistrate, right? And even the magistrates, are fobbing off. I think even Suella Braverman got a speeding ticket. She was an MP, and they also got control of a lot of them as well through the courts. It is a con in a way. It is a con, because we've been kept poor without any money, so we can never really afford proper legal power when it comes to challenging, particularly these big platforms and these big companies when they're introducing these policies. Because what you really want to do in court is challenge them on their policies, like these ridiculous things like, we can do anything we want for any reason or no reason, which is just insanely false. It's untrue. It's a lie. But they're running big companies on this. Or YouTube, kicking you off and saying, we can terminate your account, even though it's not the law. You haven't broken a law. They're making policies up which aren't even the law. But the Public Meeting Act says that they can't break up a meeting unless it's illegal. Well, if you haven't broken a law, then how can YouTube break the meeting up? Because they're making policies up which aren't the law. They're just their own rules. But yet it's not private. It's privately owned, but it's not private because anyone can watch it and look at it and read it. So if anyone can watch it and look at it and read it, then it isn't a private place. So if it's not a private place, then, you know, they're trying to kind of, they're trying to legislate things where they don't have the authority to do it. And then also, if you actually are doing something under parliamentary privileges like petitioning, and you go to court and you challenge YouTube, they can't hear the case because it's legally privileged items of information. Illegally privileged items and information can't be used in evidence. So YouTube can't win a case in the county court over their policy, because if they wanted to challenge you on it, they can't do it. But who can challenge them on it when no one's got any money? Well, when you challenge them on it, but you can't really get them in court because you're privileged. So, and this is how Congress and Parliament are giving these 77th Brigade directions. They're giving these 77th Brigade directives and telling the platforms what to do. But the only thing they're not telling the platforms what to do is they're not telling the platforms to uphold our rights and privileges and freedoms. That's what they're not telling the platforms to do. They're not saying to the platforms, you can't have that policy, it's illegal, it's infringing people's rights and liberties, right? And that's what the oath was. The oath was to uphold the rights and privileges of the people. And they removed that bit from the oath. So no MPs, no judges, no justices are upholding those fundamental liberties, which are still law. And this is how we've got this corporate platform rule, where Mark Zuckerberg pretty much thinks that he can do what he wants just because he's got a load of numbers, which amounts to money. And they've got all these insane graduate students, lawyers coming out with these insane policies that are just non-logical and can't possibly exist because no one can challenge these people. No one is in that league with the amount of money they've got, you know? So coming back to the petitions committee, so what is the deal with the petitions committee? Well, the deal is that all the way through history, people were annexing, they call it annexing evidence to petitions. That's attaching evidence. If you don't have any evidence, you can't prove something, right? We know that. It's a case. You're trying to prove something. If you can't annex evidence to it, you can't prove anything, right? Now, you could go into it's almost kind of like going into a criminal court and you've got 500 witnesses who say that you're not guilty, right? But yet there's no piece of evidence, there's no exhibit other than witnesses, right? And all those witnesses say that, they think you're not guilty. But on what basis, right? And if you had 12 or if you had 100 witnesses who come and swear on oath that they don't think you're guilty, but there's no tangible piece of evidence, the evidence presented is purely witness statements, right? Now that means you've got 100 witnesses up against a jury of 12. And the jury of 12 have got no other evidence in front of them. There's no video, there's no fingerprints, there's nothing. Only people, right? Now, how is a jury of 12 going to stand up against 100 people who say one person didn't do anything, right? In a way, that's kind of how they're running the petitions committee. They want you to get 100,000 people to say we should, change tampon tax, but you might not have any proof of, what is the proof on, on wages, on how many tampons are sold every week, on what the average profits are for the companies and what percentage of the companies make compared to other companies. And are these products even any good or not? You know, should people even be buying them? Is there any point in them? And many other things as evidence to justify why you should change the tax on something if people should, you know, have a privilege of buying more of them at a cheaper cost, or whether it shouldn't cost them as much. There are lots of evidence facts that could be presented on many different things of it, but if you don't have that evidence, you're basing it purely on people saying, you know, it's like a kid saying, I want a sweet. Why? Because I want one. This is it. Not any evidence